Hello and welcome to my lecture on drafting of a letter of intent. My name is Saber Khan and I am delighted to present this lecture. I want to start from definition and explanation of letter of intent. A letter of intent, LOI, is also called expression of interest, agreement in principle, memorandum of understanding, memorandum of intent, head of agreement, protocol, or letter of awareness. For all practical purposes, they are all the same. An LOI has a binding or non-binding nature depends upon the exact wording and essential terms to obligate the parties to the transaction. LOI is usually non-binding. However, it will be binding document if the parties intended it to be binding. LOI is only the employer's or seller's intention to enter into a contract in future. Therefore, LOI is merely an agreement to negotiate and is not acknowledged and enforceable under English law and will not impose obligations on either party. If LOI just describes that the tender has been received and contract is being prepared, then LOI with more express terms should be put in place. Otherwise, it would be unwise to commence the work until formal contract is signed off. The biggest problem arises when payment is due. It is therefore important that LOI exactly defines the scope of work with specific milestones and the price that will be paid with clear payment mode or payment plan in accordance with the achievement of milestones. However, LOI is a useful means of achieving a timely start to the works, while administrative complications delays the formal contract commencement. LOI has to be treated with care and certain precautions to be taken to preserve and reflect the intent of the parties. Possible problems with incomplete or deficient LOI. If work is carried out under an LOI which is incomplete or silent as to the terms under which the work is required to be carried out, and LOI has not specified the procedures for calculating and making payments, as no contract in place, the valuation will be on the principles of quasi-contract restitution or quantum merit basis, which may lead to disputes between the parties. There are no express or implied terms as to the fitness for purpose quality delivery or testing. There is no right of set-off or counterclaim as there is no contract in place, so no breach of contract can be established. The contractor will be under no obligation to complete the works and can cease the works at its own sweet will. The parties will not have the right to adjudicate, since there will be no contract between the parties for the carrying out of the construction operation, and obligations and right of both parties have not expressly defined. If the parties intend their LOI to be non-binding, then if the parties do not wish to be legally bound by LOI, the parties must be careful in their choice of words and title. A non-binding LOI should contain a disclaimer stating that it is not intended to and does not constitute in any way a binding or legal contract between the parties. A statement that the parties will attempt to negotiate a binding contract, but that if such a contract is not negotiated to conclusion within a certain period of time, the LOI will be void. A statement that LOI does not include all the essential terms required in order for it to be construed as a contract between the parties, setting out those essential terms that are missing. A provision of confidentiality needs to be included if there is exchange of confidential information at this initial stage. A separate confidentiality agreement may be entered into to impose binding obligations of confidentiality on the parties. This confidentiality agreement will survive the non-binding LOI. A provision that the parties are under the obligation to use their best endeavors or to act in good faith to negotiate the contract. Good faith and civil law principles. In most international jurisdictions based on civil law principles, a duty of good faith is recognized. For example, the French Civil Code states that the agreements must be performed in good faith. The German Civil Code states that the obligator must perform in a manner consistent with good faith, taking into account acceptable practice. Regarding good faith, if contracts are governed by civil law countries, then either party to the contract shall be under the obligation to inform the other party of all the relevant points that it could not otherwise discover. Observe reasonable diligence in the performance of pre-contractual and contractual obligations. Observe moral and ethical standards of behavior. If the parties intend that LOI to be binding, the LOI must state in clear and express terms that the parties intend to be immediately bound by this LOI, that its enforceability is not contingent upon the parties entering into a formal contract. The scope of work it covers and what this entails in detail, the price that will be paid for its execution, and the method, timing, and frequency of payment. Exactly how work carried out under the LOI will be valued should the contract not proceed further. Key ingredients to determine whether an LOI constitutes a binding contract. An LOI must contain the following ingredients to have a binding nature. Both parties must have intended to make a contract. There must be agreement on all the principal relevant terms of the contract, the sufficient certainty for it to be commercially viable. There must be a clear offer and acceptance. There must be a consideration. Thank you.